surrounded by our fantastic speakers and representatives here that are going to touch on some important topics around legal, taxation, immigration, and banking considerations for foreign companies doing business in the US. So I'd just like to introduce our speakers. They include Mr. Brad Richards, who's a partner with Haynes & Boone law firm here in Texas. We have on the line Nikki Dryden, who's a senior associate in Sydney for Fragerman Immigration. So we'll patch in Nikki at some point during this call. And she's accompanied here in the room by with Kelly Cobb, who's a partner here in Houston with Fragerman. Sean Orm, is also a partner here with Fragerman, and Ben Willis also with Fragerman. We also have Rafael Calzalade, who's the Director of International Tax with Panel Kerr Foster of Texas, PKF Texas CPAs, Taxation Planning for Foreign Companies, together with Olga Labrie, who's the Manager for International Tax, also with PKF. And we also have Mr. Brian Williams, who's the Senior Vice President for Commercial Banking with BBVA Compass. So again, I'd like to thank everybody here for joining us today in the room and also on the webinar back in Queensland. I'd also like to thank firstly Stephanie Grandy here in our office for pulling this together. It's a huge technical feat, and it looks like it's all going smoothly so far, and also to my team here in Houston and also in Brisbane. So the inspiration for this webinar, and we might actually take the webcam off and just revert to our slides. So we're going to say goodbye to you visually anyway for now and just revert to our slides. So the inspiration for this webinar has really come from a lot of common questions that we receive here in this office from Queensland exporters looking to come to the US, and even from companies that are more established in the US. And so we thought we'd bring together some of the service providers that have a lot of experience and knowledge working with foreign companies to hopefully give somewhat of an overview of the considerations for Australian companies looking to come here, and hopefully allow some time to answer your questions a little bit later on. So the format of the webinar is we have 4 speakers. They'll each speak for approximately 10 minutes each. That's quite a short period of time for them to cover their domain, their area of domain, but that's actually intentional to really allow some time for Q&A at the end. With regards to questions, you can send your questions through the seminar. So I think on the toolbar on the right-hand side, right, Stephanie, you have somewhere where you can actually type your questions. We'll monitor them throughout the course of the webinar, and then we'll endeavour to answer them at the end of the speaking points. We have handouts. There's also, I think on the right panel, you have 2 handouts in your toolbar that you can download, and they include an overview of the speakers, and also just a general checklist for export readiness checklist for doing business in the US. We will share the slides once we get permission, I think, from everybody here to share the slides. And this webinar is also being recorded, which we'll find somewhere to post that webinar a little bit later on. So we'll just jump into it. So just this webinar actually focuses more on the mechanics of doing business. So it's actually executing your business plan and strategy here in the US market. It's not so much focused on market entry, and so it doesn't really touch much on business development. However, we are planning to host additional webinars in the future that are sector-specific or industry-specific, starting with food and beverage, to help with that guidance in terms of your market entry for your product or services in that market, and then going beyond there. Before I hand it over to Brad, who's our first speaker, who's going to talk about some of the legal considerations, I just want to talk a little bit about some of the myths that we encounter and try and dispel some of the myths, just to give a few pointers for some of those early stage exporters to the US market to really kind of prepare them and get them thinking. And the first myth that we commonly receive is one that there's a perception that companies can service the US market from Australia. The reality is that US customers really expect and require some type of a local on-the-ground support, whether it's in business development or marketing, demand generation, fulfillment, or even, more importantly, for after-sales service and support. There's different avenues to try and take that. We can obviously help you with that. The most obvious is to direct employ somebody here in the market, but there's other avenues such as appointing a sales broker or some type of a local agent or a manufacturer's representative. The second myth, if I can get my slides to work. Can we go to the next slide, Stephen? there we go, is that your product will basically sell itself in the US market. I can't tell you how many companies we've seen that actually have exceptional products from Australia, but still manage to fail in the US simply because they don't have a clear strategy, a clear business plan, or maybe the right channel choice and so forth. So we encourage all companies to really plan for all levels of their market entry. So that includes from importation, regulation, and compliance, right through to stocking, logistics, distribution, generating demand, fulfilling demand, and then an after-sales service. This is one that I think this is one that we see more commonly from companies that are doing business in other markets where this is actually maybe the truth. This is definitely not the truth in the US. Just finding a distributor is not the golden pathway to the US market. You still need to develop all of those other elements because your distributors over here are slightly different to what you might see as a distributor in Australia or in other markets. And then the fourth myth I just want to dispel is that the US market can help generate additional cash flow quickly. It can certainly help generate additional cash flow. It's probably the quickly part of it that can confuse people. So I think companies really need to plan for treat this also almost as a new venture when you're coming into the US market. And so as a new venture, you want to make sure that you're properly funded for that period until you become cash flow positive. So one of the documents that's in those handouts is an export readiness checklist that we've compiled based on some of the more common questions. I won't go through that, but you can have a look at that and feel free to ask any of us here at TIQ here in Houston or in Brisbane or in anywhere else in Queensland for any advice with regards to that. So with that, I'm going to hand over to Brad Richards with Haynes Moon to talk a little bit about legal considerations in the US.
Well, thank you, David. Thank you also, Stephanie, for your assistance with this webinar. And good morning to everyone. By way of background, I've spent over 30 years advising foreign investors coming to the United States. As of September 1, I will be jointly resident in Houston and London. I'm taking additional responsibility for an office there. I plan to just make some brief comments here about the initial legal considerations for investing in the United States. And we're a big country and we're complex. And just as in Australia, you can't talk about investing in Western Australia and have it apply in Queensland. It's similar in the United States. So I will begin by reminding the listeners that there are so many different ways to enter a new market of any kind and establish a business presence, and that's certainly true in the United States. There is an open business environment, particularly in Texas, I must say, and it means that for companies who want to access the U.S. market, they can do so through a wide variety of vehicles. Because the United States has a federal system, each state has its own business laws, and of course there's federal overlay to those laws. But most basic issues that you'll confront are probably going to be state law issues, especially initially at the beginning stage. A lot of companies do come in and consider using representatives and agents for the reasons that David articulated. The key issue in using representatives is to think through whether you're subjecting yourself to U.S. employment laws, and because, of course, there's going to be protections. Some states are very aggressive in protecting employees, states like California, for example, which can add significantly to the cost of having an employee. And if you prefer to have a more permanent office, you can establish a U.S. representative office. If the office itself doesn't generate its own income, in other words, the sales will still be out of Australia, which depending on the type of product might work for you, then this type of office might limit the amount of liability. You may end up just with liability for local staff, having contractual liability for your lease, and have a less complex structure. It's important to consider whether or not you're doing business, and I put that in quotes, in a state. State laws throughout the United States vary regarding what the tests are for what constitutes doing business, but generally most states look at three different things: the doing business for purposes of getting sued, which no one wants, the doing business for purposes of being taxed, which nobody wants, and doing business for purposes of being regulated and needing to become registered to do business in a state, which people usually don't mind too much. While we don't have the time to really discuss all of those issues, suffice it to say that if you are simply selling a product into a U.S. state from Australia and you have no U.S. presence whatsoever, you're generally not going to be subject to a whole lot of taxation or regulation, which is good news. Of course, then you don't get the advantages of the after-sales service and having someone in the market who's actively selling for you. As you increase your presence in the U.S., you're likely to need to both collect and pay taxes if you're trying to sell a product, and you'll need to register to do business, and you'll have to consider all of those additional regulations. Some investors from outside the U.S. Want to form U.S. partnerships and joint ventures, and part of the idea there is to try to lessen the workload on you. You get someone else who already knows the market, they have developed the market, they may understand your business, but I think it's really critical to think through the process of structuring any kind of a partnership or joint venture. Make sure that you provide both the protection for liability for you, protection of the investment so that you can get a return on the investment, and finally so that there's still compliance. You don't want to be doing business with someone who fails to pay taxes or fails to file government forms. So typically a U.S. An investor in the United States will think through and establish some type of a legal entity to invest in any kind of a partnership, and my biggest liability shifts then usually to who the partner is. A lot of people make a big mistake in terms of who they select as their partner. That's where the biggest headaches that seemingly come back as legal problems that I hear about is that there's a problem where the local partner is stealing you because you're not keeping track of accounts, or they're just failing to do what they promised to do, or and you can fill in the blank. The local partner has an advantage because they understand how to use the local law to their advantage, and they also have a better sense of the commercial risks and rewards in the marketplace that typically drive decision making, which means that they can substitute their judgment for yours. So it's very important to really think through who you're doing business with. Take advantage of all of the due diligence, including that of the government of Queensland, the U.S. government, anybody who will provide you with information. It's obviously somewhat in my self-interest to say it, but I have to say I have to recommend to you seeking professional advice if you're going to form any kind of a joint venture. A good advisor will make sure that your rights, including your intellectual property rights, your rights to the return of your investment, are all being protected. The next stage that a lot of people think about, and some of you may already have done, is to form a company. It could be in furtherance of a joint venture, or to establish local manufacturing or local distribution, to have a local operations, and many investors do that. There are different types of business entities, each of which have their own registration and operational requirements. Traditionally, investors form a corporation, and the traditional reason for doing that is to obtain limited liability, try to build value in an entity itself. It's easy for third parties to invest in and inquire. You can focus the liabilities on the tax liabilities on the entity. You can separate the shareholders and their tax situation from that of the entity. In any event, I'm sure that Raphael will be addressing this, but tax considerations are paramount as you determine what kind of entity to form, and so you'll want your legal advisor to work closely with your tax advisor to create the optimal entity for your investment. One must keep in mind that no legal entity will accomplish your business objectives if you fail to manage and operate it in compliance with law. We have this nasty theory of legal liability we call piercing the corporate veil, and it has pierced many a weary investor's heart because you can get sued if you're not maintaining the company on a regular basis and making sure that you're in compliance. Now, at the high end of complexity is buying a company. Because the U.S. thrives based more on self-regulation than governmental regulation, and we could probably debate that in this room, but relative to other places in the world, it's a relatively self-regulated environment when it comes to business. And as a result, many of the basic issues around company operations and where potential liabilities lie are knowable only by doing and conducting due diligence and on a prospective target. Among the issues I typically see and typically require the extensive work by attorneys and by accountants and by consultants relate to issues like the environment, environmental issues, employment law issues, intellectual property issues, tax issues. They all can be a problem. With respect to the tax issues, there's a very fundamental point that you have to think about at the very beginning, which is, are you going to be acquiring the assets or the equity of the entity? And they have different tax treatment for both the buyers and the sellers. Thus, once again, I have to say it's important that all your advisors are consulted on how to structure the transaction. It can have meaning as well with respect to immigration, if you have an employee who's going to be moved here. So you want to think about all of those and how they interrelate and make sure your advisors are talking to one another so that you can get the best possible structure. I should also mention that the U.S. does sometimes at least enforce its antitrust laws. So if you are in an industry where you control a significant share of the market for a product, or if you have distribution channels that highly restrict who can sell or resell your product, then you may become subject to U.S. antitrust laws. I'm going to kind of close out here by discussing some basic operational issues because I think, as I think about the area of greatest concern as you contemplate an investment or manage an existing investment in the United States, I think I would be derelict in my duty if I failed to mention that operating an entity in a new location must take into consideration the local regulatory environment. And as I mentioned earlier, you really need to address and observe the local corporate formalities, the formalities of running a local business and those regulations. I see a lot of liability around employment and the employment and bringing in employees and having them operate locally, and then those people end up suing you, or you get sued, or you receive requests from the government regarding what you're doing with respect to them, whether they're properly employed. So that regulatory compliance environment is something that you really do want to pay attention to in the United States because the regulators, when they do regulate, will pay attention to it. If you enter into an agreement with a U.S. company, you may want to consider trying to get the counterparty to agree to arbitration. A lot of non-U.S. investors prefer basically to choose the court rather than use local courts. And Australians certainly are going to be familiar with the operation of a court, and the U.S. judicial system is great, but there also are pitfalls in being subject to a local court. And we see here in Texas, for example, courts that are very favorable to patent trolls, for example, or courts that are very favorable to products liability lawyers. Sometimes that's something that can think about. It's not possible in all situations, but it's something that you want to look at. I have to say that, fortunately, in my mind, as a lawyer, I have to say that I wouldn't be too scared to come to the U.S. as an investor. We share the English common law system as the foundation of our legal systems, so reliance on the law and legal system to address grievances is well understood by all of us. We have a federal organization, so we have this federal overlay, which is also well understood. We have a lot of treaties in common. We have a bilateral tax treaty, which will probably be mentioned. We have a lot of similar types of protections for the environment and for employees. Therefore, my hope is that if you come to the U.S., that you will not find yourself a stranger in a strange land, but rather a welcome investor in an open market with outsized opportunities. Thank you very much.
Thanks very much, Brad. I believe we're now going to throw over to Nikki Dryden, who's a senior associate with Fragerman, who's actually based in Sydney. We won't hold that against her, given this is a Queensland webinar, but we'll still allow her to participate. Nikki, hopefully you're on the line and you can hear us and are able to speak.
Yes, I can hear you well, thank you. And I would love to move to our Brisbane office if, you know, Kelly and Sean as partners in Fragment will allow me. I'm seeking warmer weather always, so making my way farther and farther
We can
south.
talk about that after, sure.
So I'll just quickly introduce myself while I'm speaking, then I'm just going to have Kelly and Sean also do so. As mentioned, I'm a senior associate based in Sydney. And what that means is that I'm one of only 2 American immigration lawyers based in Australia and one of only a handful over in Asia Pacific. And what that allows Fragment to do is to provide on-the-ground experience, in particular around the consular processes that are involved with many of the visa applications that are made in order to go to the United States. So I've been working with Fragment here in Australia for about 2 years, and previously was in our New York office. And now I'll hand it over to Kelly and Sean quickly.
Cobb. Hi, I'm Kelly Cobb, and I'm a partner here in the Houston office for Fragment, and we have 2 Fragment offices here in Texas. So I'm fairly new to the office, almost 3 years, but Fragment's decided to open the office based upon there's so much existing business and so much business coming into Texas. So I primarily focus on U.S. immigration work.
Kelly, thanks. I'm Sean Orm. I'm a partner in the Houston office. I've been with the firm for a relatively short period of time, 4 to 5 months. I focus on both U.S. and global, and therefore work very closely with Vicki and her team in Australia and our other offices, 45 in total throughout the world. So back to you, Nikki.
Okay, next. All right, so the first thing we're going to talk about today is the visa waiver program, or B1 status. And so, you know, as you guys are starting out in the United States, maybe you're meeting with some of our colleagues on the panel today, you're traveling over to the United States most likely using the visa waiver program. You apply online using ESTA, and what that is it's a special program that allows Australians, as well as people from certain other countries in Asia-Pac, to travel to the United States without having to get a visa first. It allows you to stay for up to 90 days on any one trip. This doesn't mean that you should be staying for up to 90 days, and I think where a lot of people get into trouble when they're foraying into the U.S. market is that they see the 90 days, they think exiting for 1 or 2 and going back again is okay. You know, just because of status, you receive a certain amount of time in the United States doesn't mean you should necessarily use it. Because what the visa waiver program does is it actually allows you entry into the United States in what we call B status, and as a business visitor. Technically, you can also get a B visa, which has the same terms and conditions. And what it's appropriate for, so whether you are using the visa waiver program or you're traveling on a B1 business visitor visa, is that you're performing passive activities in the United States. And those activities are to promote international trade, they're to benefit your Australian entity. So going over there to start up a business, it can be okay. There are some sort of parameters around whether you're going to be doing an investment. You are allowed to do precursors to that as long as you don't start performing productive work in the United States and actually managing that business. Next. And so one of the things, the big picture requirements for going over there to get things going is that you have to be on your Australian payroll. You have to have the support of your Australian entity still, and you should be doing productive work in order for that Australian entity. So it does become complicated as the U.S. Opportunities grow to transition. Because there's not like a transition visa or a short-term visa to get you started the way there is coming into Australia. So I'm going to hand it over to Sean and Kelly for their thoughts on some of the things to look out for when you're coming in on the visa waiver program.
Yes, Vicki, I think it's really important. You hit most of the points. It needs to be clear that you're coming in either on the B visa or the visa waiver, that this is short-term. You're visiting. You're not going to be involved in productive employment. That's really the most important thing. I mean, I know whenever I going through an airport in another country, if I'm there, even attending meetings, I think it's there for work. If I'm going to a seminar for business, I tend to think of it as work. However, when you're coming in to attend meetings or just to look at different business opportunities, just to visit the city, you need to be very clear that you are coming to visit. You're not involved in a productive employment. Clear that you're just visiting, and that there's no concern that you're going to be here conducting business.
Yeah, I think the key here really, we have some of a cautionary tale, as Brad did earlier, is to really have a plan. I think what you don't want to do is let your employees tell you a story about their cousin or brother who came over and there was no problem, because what they won't tell you is, for everyone that made it here and didn't have a problem, there are many others that did, and that will and can prohibit business in the future, and you can really jeopardize your whole business venture by getting hasty. So again, I think the point here is have a plan. Sit down, get with your counsel, look at your business plan, find out staffing needs, and most importantly, meet with your employees and get them prepared before they enter, because what will happen is our friendly folks at CBP are going to ask them what seem to be fairly innocuous questions, starting with, how is your day, and ending up with, so you're really probably eventually going to have to come for work, right? So they're very disarming, but every question they ask is meant to trip someone up. And the sharing of information, both at CBP and CIS in the United States, is getting much, much better. So the point here is really have a plan. Sit down with your employees. Don't let them talk you into jumping on an airplane. I got this. My cousin did it. Or I did it in my old company. Just really have a plan. Sit down with your counsel and really understand staffing, what you're doing, and most importantly, make sure that your employees are prepared.
Great. Next. So now we're going to just jump ahead a little bit. So now you've actually you've spoken to all our colleagues on the panel, and you've actually incorporated in the United States, and now you're ready to send over your first employee. Perhaps it's you as the CEO, perhaps it's a sales manager or marketing manager. Australians are the luckiest people on the planet when it comes to U.S. immigration. Australians have a special visa that no one else in the world has. It's better than what the Canadians have, and which says a lot about the treaty that was made 10 years ago between Australia and the United States. There's a couple of requirements. The employee going to the United States does have to have a bachelor's degree or related. And I would say that over 70% of my Australian E3 applicants don't have a bachelor's degree. We are using professional experience to qualify them for the E3. So don't let that slow you down. The other thing is that the person does have to go onto U.S. payroll. So I think that's also, we're talking today about a lot of considerations that you have to make and a lot of players that have to come together and talk to each other. And so, the E3 is fantastic, but the limitation is you do have to be on U.S. payroll within 30 days of arriving. And before we can get you over there, we do have to have what's called a labor condition application submitted to the Department of Labor to prove prevailing wage, that you're going to pay that person a particular wage for the location. Again, none of my Aussies usually have a problem with that wage. It's all pretty reasonable. But that document does have to be posted up on 4 walls in the United States. So again, a lot of my clients who are just starting up maybe are using, some of them might have offices, some of them have a warehouse that they can use, some are using shared office space, which is fantastic. It's a great way to get going in the United States. And then, some people are using a home office, but that's my least favorite way of moving forward. But it's all doable. We do E3s for all walks of businesses. Next, the last one we'll just quickly jump into is if your employee is not an Australian, perhaps they're a Kiwi or someone from Asia who's living in Australia and has permanent residence, perhaps we're going to have to look at a different visa category. There are a lot of them. This one in particular requires a lot of foreplanning. It's not great for small businesses who are starting up. There's limitations if the U.S. entity is less than a year old. But it does allow you to move over managers and people with special knowledge who've been working for your Australian company for at least a year to go over to the United States to either help set up the business or to work in the existing business if they're qualifying entities. So there are options for non-Aussies, but it's just, Aussies are the best, so they're very lucky. So Sean and Kelly, final thoughts on these visa categories for once you are really getting going.
On the L1, we do quite a few of what we call new office Ls. So an L1 and like you said, there are a lot of hurdles to go through, but when someone wants to come over and establish an office, and that's when we work with other practitioners to establish a business, to get their tax situation, to get that lined up, to become incorporated in the state, and then we handle the immigration piece to establish that new office. And then they can bring in other L holders that work for them abroad, or if they want to bring in another Australian that possibly doesn't work for them abroad, we bring them in on an E3. So that's doable for new businesses. There's also, I know, Sean, you've probably done a lot of the E1, E2s for new businesses.
Absolutely. And I think the key, the broader observation here would be, when you meet with your counsel, as you can tell, a lot of the Immigration Act can be read very broadly or very narrowly, is really get with counsel that's going to help you make a good business decision. And what we're big proponents of is mitigated compliance, is reasonable compliance. So make sure you share your goals and what you want to get accomplished with your counsel, and then make decisions from there. Because I think our role as a lawyer is not to necessarily tell you what to do, to tell you what the law provides within certain boundaries, and help you make a good business decision. So I think there's a lot of options here. Each are very idiosyncratic. It really depends on a couple of nuances here or there. But most importantly, when you meet with counsel, find someone that's going to help you make a good business decision. It's going to see your business more broadly and help you develop a plan and stick to that plan.
Thank you very much, Sean, Kelly, and Nikki. Thank you, Nikki.
Thank you, everybody.
So we'll move on to our next speaker, which is Rafael Calzalade from PKF Advisors. So hand over to you, Rafael.
Thank you, and good morning to everybody. I'm just going to jump right in, and time is short, and there's a lot to talk about. But just to give you a little bit of a background, I work on the international tax side, and most of my clients are in the situation that you're thinking about getting into, which is what we call the inbound, foreign companies coming to the U.S. And we've seen a lot of activity of that in the last 12 to 18 months here in the U.S., so you're not alone. The objective of this presentation is really going to be to give you a broad overview and make sure that you're not hitting some traps or some myths that we see clients get into all the time. And so brief overlook at the agenda. We're going to look at overall perspective, and we're going to talk a little bit about the corporate side, a little bit of the individual, and just some myths or common traps on the back end. Overall, on the overall perspective, one thing to keep in mind is that the U.S. entities and individuals are taxed on their worldwide income. So if you're a tax resident, you're taxed on your worldwide income. As a foreign entity coming into the U.S., or an individual is non-resident, you are going to be taxed on your what's called the U.S. source income. That means it has different definitions, but basically income that's generated or earned from a business here in the U.S. Another thing to keep in mind, and what Brad kind of mentioned earlier as well, is that like on the legal side, for taxes, you have several taxing jurisdictions. There's a federal, states, and city and municipal level taxation, and all of them have the ability to tax income. Not all of them choose to do it, but they do have. And also one key thing that's different in the U.S., there's no U.S. federal sales and use tax. It's the sales and use tax is done at the state and local level. And we also have an estate, which is an inheritance and gift tax regime that may also apply to non-residents. So if you're sending people over here, they're going to have to be careful with that. Another item that people from outside of the U.S. are not used to is that we have domestic double taxation. In other words, your corporate profits are taxed twice, one at the entity level, and also the shareholders, when they do receive a distribution or a dividend, that dividend is taxable again. So it's inherent in the U.S. tax system that you are going to be double taxed if you choose to go with a corporation. Now, there is a treaty with Australia, and the treaty does allow for avoidance of double taxation between the U.S. And Australia. But keep in mind that the domestic double taxation is still going to happen. And another thing to keep in mind as well is that the states are not bound by the federal treaty, so you may find yourself in strange circumstances. So on the entity level taxation, the minimum threshold is doing business in the U.S. I'm not going to talk about that because with the treaty in Australia, we have the concept of a permanent establishment, which basically allows an Australian company to come in the U.S. and do a higher level of activity without being considered taxable in the U.S. So some of the things that you may think that would create a business presence, like holding inventory in the U.S., could be exempted under the treaty. A direct sale to a U.S. customer or to a U.S. distributor where you're not doing the business here in the U.S. Would not create a permanent establishment. If you do have an office and you do have employees here, more likely than not, it will be create a taxable presence unless these are just basically salespeople. And a U.S. broker or sale agent as well, you have to be careful. Normally they do not create a permanent establishment, but it could happen that it does create, depending on the level of the relationship. Another thing to keep in mind is that even if you qualify for those benefits, you have to file a U.S. form claiming those benefits, a U.S. tax return with the authorities. Otherwise, you are going back to the lower standard, which the taxation starts much sooner. And on the state level as well, you have to be careful because the states also have their own definition of what's doing business, like Brad was mentioning earlier. Is the same thing for tax. So your concept of doing business in one state could be completely different on the next state, so you have to account for that as well. In terms of a lot of the questions we get is what type of entities are available. I've given just the four main ones. I'm not going to touch on the S corporation because that's usually has to be owned by U.S. individuals. So most of the cases we don't see that for foreign companies coming into the U.S. The C corporation is very widely used. The partnership has its benefits if you have a U.S. partner or the owners are a U.S. person living in the U.S. Otherwise, most of the benefits are not there. And you hear a lot about the limited liability company. The limited liability company is basically a wild card. It can be anything taxation-wise. It could be completely disregarded. It could be a C corporation, S corporation, or a partnership. So, you know, what Brad was saying about when you're getting ready to set up an entity, make sure you're talking to a tax advisor because the fact that it's an LLC doesn't mean that the taxation is set. One thing that you'll notice as well is that the federal tax rate is generally 34%, and then you have another level of state and locals that could be, you know, anywhere from 0 to 10%. And there's also dividends taxable to shareholders when that money come out. So the tax rates in the U.S. are, if not the highest in the world, they're definitely in the top 2 or 3. So you have to keep that in mind because that's the type of surprise that could kill your margin coming into the U.S. In addition to the non-income taxes, in addition to the income taxes, you have the non-income taxes like sales and use tax, the payroll tax, and the property tax. I'm not going to dive too much into it here, but I've got some on the slide, a little bit of an idea of how it works. Just remember, there's no VAT, there's no federal sales and use tax. It's just at the state and local level. For the individual taxation, you'll probably be sending some people here. Again, the U.S. tax residents are taxed on the worldwide income, and the non-residents are still taxed here, but just on their U.S. source income. Again, the treaty provides a definition of residency that unless basically you move all your center of vital interest to the U.S., you can still claim to be a resident of Australia, a tax resident for Australia. That doesn't mean that you're going to be exempt from tax here. You may still have to pay taxes here for the work that you are doing here and generally claim a credit back in Australia if you're getting taxed on that same income. I've got the tax rates listed there. Another thing to keep in mind is estate inheritance taxes. There is a treaty between the U.S. and Australia as well, but you have to keep that in mind, especially if you have employees or owners of the company coming to live in the U.S. and become U.S. tax residents. One key thing to leave with you there is that any individual tax planning that you do has to be done before you move to the U.S. Or before the employees move to the U.S. Waiting to get here to come talk to the tax advisor, at that point, you've basically exhausted 95% of the opportunity to do any planning. So it needs to be done while they're still in Australia. And finally, I think some of the common U.S. tax traps that we see from foreign businesses and what David mentioned earlier, the myths. The key thing there is the U.S. tax system is very complex. I deal with international tax, and maybe Brazil could be a little bit more daunting, but not by much if that's the case. You have to be careful because you are coming into one country, but basically it's over 300 taxing jurisdictions. Every time you go across state lines, there's a different set of state tax rules and state tax rates and what's taxable and what's not and when you have to collect. So you have to pay a lot of attention to it. I'd say it looks more like going into Europe than really into a single country. What Brett, and then I'll harp on another thing too that Brett mentioned, is it's a self-regulated environment. The U.S. tax system is not designed to identify issues immediately. Those could be out there for 5-10 years before somebody realizes, and at that point you have retroactive penalties and charges. So just the fact that you're filing and the IRS is not asking you any questions doesn't mean that everything is fine, and that's why the tax planning is very important on that side. And the treaty benefits, they're there, but you have to apply for them, and you have to be careful because some of the states don't recognize the federal tax treaty. So you may be paying taxes in the state even though you're exempt at the federal level. Corporate tax rates are very high. They could, if you're not planning properly, it could be close to 50%. So it's definitely something that you don't want to take lightly. Again, individual tax planning must be done before leaving to the U.S., before acquiring U.S. residency. And also, in terms of owning U.S. property, you have to be careful because there are inheritance and estate taxes that could apply. But to sum up, I think Sean had mentioned you have to have a plan. You can come without the plan, but it's going to be a lot more expensive on the back end than spending the money up front to make sure that you avoid all the surprises.
Really good advice. Thanks, Raphael. Much appreciated. So I'm going to throw to Brian Williams, who's the Senior Vice President, Commercial Banking with BBVA Compass. Before I do that, I'm just going to encourage anybody who has a question to please put through any questions. We haven't received too many questions yet, which is really surprising given what I know about people from Australia and Queensland. They only have 1 million questions. So don't be shy. Shoot through some questions for any of the speakers or for all of us. For after Brian's presentation. So I'll hand over to you, Brian.
Okay, David, thank you very much, and very happy to be here. The first couple pages I'm not going to go through. It just talks about my bank here, where we're primarily in the South and West. But with time constraints, I'll go ahead and go to page 3. As in terms of what a company's primary concern is, as in terms of financing, possible operations here, warehouse, distribution center, all that. But the main challenge is, at the end of the day, is what banks see as lack of credit history. And it's really a big deal here because you have to, because of how our stringent banking regulations are here, we really have to dot our I's and cross our T's as in terms of how we know our customer here, which is called the KYC process. And so when you're looking at having this newly created entity, there's no collateral when you start up here. one of the things that most banks, if they have a robust international department, is the pretty much the primary I can't talk, sorry, the primary acceptance of foreign parent guarantees, and that's probably where you all have to pretty much focus on if you want any type of financial support here. What most banks will look at if your parent company is really financially strong, we'll look at pretty much looking at the financial condition there that will replace the lack of credit history here. Or sometimes some parent companies will go to their local bank there, and they will provide us with a standby letter of credit that would back up any type of loan here. So the next page here is all the different type of products that you want to look for. However, you want to choose your bank wherever you go here in the U.S. that they do have an international banking department that has all this. If you go to like a medium-sized bank in Chicago, Nebraska, or wherever you're going to have your operation at, you really want to make sure that they have an international banking department. And when you're wanting to open up actual checking accounts, one question that you guys might want to ask is there a platform set up where they can pretty much accept foreign signers, where you can have actual access to that. And one of the things too is when you are wanting to set up some type of banking relationship, since the credit crisis, the banking regulations here have gotten what I'll say is worse and worse, and more paperwork is how I want to call it. And so if you provide what banks need, and because of foreign entities coming in here, you know, we've had a whole lot of history here in the U.S. with problems with banks that have dealt with Russia and those type of countries that are on our OFAC list. One of the things that we kind of ask the companies coming here is that pretty much have patience with us as in terms of the information that we need, because we pretty much need the U.S. company formation documents, let's say that you would do with Brad. We would need parent company financial statements. We would need also parent company formation documents from the actual host country, and then also too just getting a better understanding of who the management is and all that, because at the end of the day we have to validate to our bank regulators who our customer is. We have to really know the customer in and out. It's not just the parent company financials, it's all that. It's really knowing who your suppliers are, because if we find out you're doing 40% of your business with some country in Africa that's on the United Nations list, that's going to be a problem. And so we want to make sure that we have to dot our I's and cross our T's. And that's pretty much it. At the end of the day, going to the last page on page 7, these are pretty much the main categories that we look at when we actually go into underwriting for loans and things like that. So that just kind of gives you a brief overview of the type of detailed pieces of information that we need. And that pretty much just kind of wraps it up. One other thing too is some banks like ourselves here do offer what is probably really important to a company is for its employees, as in terms of providing credit, because when you have your expatriates here, they need cars, they need credit cards and things like that. And most American banks do not give credit unless you have American credit history. So you want to find a bank. We actually do it here and throughout the country, but if you're in Chicago or Raleigh or New York State, there may be a bank outside our footprint that may offer loans to expatriates. So that's one question to ask as well.
Excellent. Thanks, Brian. There's two Australians in this room that have gone through that exact experience. Myself and Ben, so you should never underestimate that.
You need some help now?
Yeah. You never underestimate that point of that.
Yeah, we were 2 years ago.
Personal credit history. So we're thanks so much, Brian. That was very good. We're just going to take a look at some of the questions that have come online. So there's some specific ones. I think we may just read these out there, given that they're kind of specific. So the first one is on an E3 visa, obviously an immigration question. They must be paid on a U.S. payroll. Does that require setting up a U.S. company, in the U.S.?
I can answer that one. Yes, for the E3, there must be an employer in the United States, and that employer must guarantee to pay what's considered the prevailing wage here in the United States. So yes, they're going to be payrolled here out of the United States.
Second question, specifically from Mr. Brad Richards. You've been called out, Brad. It's about dealing with the FDA. Everyone wants to talk about that. How it looks like it's specific to somebody, and he said it's specific to first aid, regulations guide to first aid. So.
Right. Well, and I have to disappoint you on this one in that the regulatory compliance with the FDA is a very specialized area for legal advice, and in fact, probably most of the lawyers who are very familiar with the regulations are located in Washington, D.C. So I don't know specifically the answer to your question, but I would say that prior to undertaking any type of trial, I would want to know the answer to your question. I know that's not very helpful, but it's to recognize the value of the question.
Yeah, and Amy, and really for everybody that's on this webinar, we'll provide the contact details for I think everybody in this room that wants to be provided. Yeah, and it's also on the handout, and we can also make that connection to.
Yeah, right. And I would add too that I certainly can provide appropriate referral in that. Type of matter.
Yeah, right. So I mean, the answer really answered. There's specialists in FDA regulation. Yeah. Other question. We have a Queensland-based company looking at taking on a California-based representative. Looks like for a 90-day trial. What's the best way to do this and stay compliant with local laws? It's probably a labour law. Is it an individual or a corporate? Good question. So. I'm assuming maybe like a sales broker, like a contracted sales broker or representative, manufacturer's representative, sales agent.
Yeah, I mean, I think that this question, I would answer that if you are going to be working, and now I'm going to assume first of all this 90-day trial is not a drug trial, and then we're back to the FDA question. But if we're talking about basically trying out a local representative. One of the most important things here is the compliance, back to the compliance with the employment laws. In most states, if you have a temporary employment relationship, you're in pretty good shape in terms of avoiding, from a total employment law standpoint. I'm not talking about here whether you're employing a foreign person who may be subject to immigration laws, but just from an employment law standpoint, a short-term test, where the person is being tried out and you want to put them into use is not going to create a long-term employment liability. However, what sometimes happens in this situation is companies will enter into written agreements, and those written agreements may create additional obligations. So what you typically would want to do is make sure that there is a very, very clear understanding as to what it is you're going to be doing during that 90-day period, because you could create liability that is unintended.
And this is Raphael. I'll comment on the tax side of that as well. You're, like Brett said, you want to make clear what the role of that person is. You will probably want to stay away from giving them any authority to legally bind a company in the state, because that would create a taxable presence. You'd want to try to shy away from possibly, I mean, if at all possible, giving them business cards with your company to give the appearance that they can bind your company. In general, you'd want to make sure that some of the things are in there, but just having, for tax purposes, having a person there for 90 days generally does not, especially if it's in a sales, sales responsibility, doesn't create that. One thing I'll add to that is, I always talk about states being different levels of taxation. California is as aggressive a state where it comes to taxes as you can get. Usually California and the ones on the East Coast, like New York, are very aggressive. So you'd have to take extra care not to trip anything there. I mean, it's a great market, and I tell people don't do anything for tax reasons because they're not interested if you're not making money. So tax will always come second, but just be aware that California is a tough place in terms of taxation.
Thanks, Raphael and Brad. So going down, one of the other questions is around manufacturing in the U.S. Does it establish a case for doing business in the U.S.? I imagine that's a yes, and therefore requiring regulatory compliance.
Yeah, and this question I'm just going to answer very quickly and to say that if you're going to be doing manufacturing, absolutely. But what behind your question, there may be whether or not you could do contract manufacturing in the U.S. And you could do contract manufacturing where the real issue then becomes whether or not you're transferring intellectual property. And I don't know if that's behind your question, but you may be transferring intellectual property if you're doing contract manufacturing. Typically, though, if you're doing contract manufacturing, the regulatory compliance is going to be done by the manufacturer and not by the owner of the idea.
Yeah, and from a tax perspective, most likely, yes, you're going to have compliance here, unless you're completely doing contract manufacturing where you have no control over the manufacturer themselves. But if you're intending on building the things here or directing somebody to do it, at the end of the day, it's most likely going to create a presence, and you should probably be thinking about starting with a legal entity in the U.S. Already, and not try to do it with the Australian company.
Specific question, Raphael, for taxation. So you did a checkbox registration for LLC operate only at federal level. That is, will some states automatically treat a corporation and no election available? Is that referring to?
Yes. Yeah, the LLC, like I said, is the wild card. The check the box is basically where you elect how you want your LLC to be taxed. Most states do follow the federal treatment, but not all. There are certain states that will require you to make an additional election in their state. But in general, it will apply to all the states, because the states generally calculate taxable income starting off with the federal taxable income, and so they'll make those work. So the answer is generally yes, but again, you just have to make sure you understand that in the state that you're going into, that also applies.
All right. This question is with regards to due diligence for a joint venture. So it sounds like the question is it common for the counterparty to conduct due diligence when considering a JV with U.S. local organizations? Is it common for them to do some due diligence maybe on the Australian company as they
Oh, I see. Yes. If somebody is going to be entering into a joint venture with you, I think they would be wise to do due diligence on you. So that type of relationship, I would say that a joint venture is the same as a partnership. You have a lot of the same issues from a tax standpoint as you do in a partnership, and the joint venture itself ends up with each party ineffectively being married to the other party and taking all the problems of their counterparty with them. So wise people always conduct due diligence on their counterparty.
And I may have kind of mixed that question. I think the question is asking around where can you get some services for actually doing that due diligence as well?
Right. Yeah, and typically due diligence is a many splendid thing. So if you're doing due diligence, you want to have a series of people who understand the issues that are the most important. So first of all, you want to identify where the potential exposure is, and then get the experts who can provide that. So it might be that the biggest exposure is tax exposure, and you really want your PKF to go ahead and do a whole lot of due diligence on the filings that the company has done. But it may be a brand new company where it's all very clean, and that's not the issue. Instead, your big problem is it involves real estate, and that real estate has potential for environmental damage, in which case you'll want an environmental consulting firm to do your due diligence. So it depends a little bit on what we're talking about. Okay.
Another visa question. Using the ESTA visa, can you visit a manufacturing operations in the U.S. on the ESTA visa? On the visa waiver, sorry.
Yes, if you're visiting to observe and maybe meeting with the owner and getting an idea of how they operate, and if you're thinking about maybe going into a joint venture with them and you want to discuss it, yes, you can enter on the ESTA.
Okay. Sorry, I agree with that, but what I would also do is I love having folks enter on ESTA or B1 carry a letter clearly delineating, signing the Foreign Affairs Manual where most B1 activities are delineated, so it's clear, because what you could be right, the counsel could be right, but the person at CBP, they often, I say, don't know what they want until they don't get it.
Yeah, right.
And so it's clean, right? You read the letter, but when you start engaging in a conversation, a guy's coming off a 13-hour flight, their goal is to trip you up.
Yeah.
I've seen people who are here for very clearly permissible activities. They get sent back because they just got confused. So I think the advice, and I agree with Kelly's assessment, carry a letter, have it delineated, have a counsel spend 15, 20 minutes so the guy carries it, reads it, drops it in, and you're going to really mitigate against getting stopped if you do that.
Okay. Specific question for a company that's looking to acquire kit equipment in the USA prior to setting up a business. They've got some advice that Montana LLC is the best for passive non-income earning assets. Specific advice. But the only way to achieve registration is insurance. Yeah. Any comments on that one?
The only comment I'll make is not specific, and I apologize, not specific to your question, except this, that because we have this federal system and the states compete, we have had a situation where a number of states recently have tried to come up with unique products that they can sell. And those products might be an LLC form that doesn't require as much, that it's easier to get forms faster, or it doesn't require as much regulatory compliance within the state. So it may be that in this case, somebody has recommended Montana simply because of a limited regulatory requirement. But I will caution you on this. Very rarely do investors benefit by forming a company in a jurisdiction that's non-traditional. And the reason is because when you look at your plan, to go back to the plan that Sean was mentioning a long time ago, you go back to your plan, your long-term plan, typically you're saying, I want to be really successful, I want to sell a lot of products, I want to have a really successful company, and someday I want to sell it, or I want somebody else to invest in it. And if that's the case, you don't want to be in Montana. And that's not a prejudice of a Texas lawyer, it's just the prejudice generally of investors.
Yeah. It's also the concept of legal certainty. You want to be in a jurisdiction that's used to having investors and selling companies.
Yeah.
I mean, that's just a basic tenet of practicing law. It goes towards legal certainty.
Yeah. Yeah, and on the tax side, there's really no advantage. If there is, it's so minimal that it's probably the last thing on your list. The first thing I'd caution is an LLC with only one owner, it's disregarded for tax purposes. So it's as if the Australian company was doing business in the U.S. So you want to be careful with the LLC with just one owner. But the states, a long time ago, people would pit the states against each other by putting revenues in lower states and everything else. The states have gotten wise to that, and basically they'll charge you tax whatever you're doing the work. So if you're not doing any work in Montana, but all the work is being done in Texas, Texas will charge you. Montana may not, but Texas will still charge you. So you're really not getting any benefits from locating in for tax purposes in a particular jurisdiction in general.
Yeah. Simple question: can we please get copies of the slides? I say yes. You will get copies of the slides. This is an interesting one, actually, and I think we're coming across more and more of these. And this is internet companies, so maybe e-commerce companies. This is a Queensland company that moved into the US market. Should they have a US domain URL, and probably more importantly, should they have a US bank account for people buying the product? I think more broadly is what are some of the maybe even tax implications of selling into the US when you in terms of sales tax. Can you speak to that, Raphael or Brad?
Yeah, I'll start on the tax side. Just selling a product into the U.S. generally does not cause you to have a taxable presence here. If you set up a server that's located in the U.S., that usually flips the switch, and that server can become a permanent establishment of yours here. So now you become taxable, which again, if you're planning accordingly, is not an issue. We do have clients that do sell in the U.S. and they found that credit card companies usually like to make payments to U.S. entities, and so you're going to have a hard time trying to practically getting your customers to make payments by credit card if there's not a U.S. entity. Registering a foreign entity is very hard, so from a practical perspective, you may need to do that just to be able to charge your customers. Again, tax is always second plan, so if you need, that's the way you need to do it to charge your customers. There are ways to make sure that from a tax perspective, you're not getting penalized.
Excellent. Question with regard to the myth from the first slide. Talking about the expectation of the U.S. customer for after-sales support and being on the ground. The question is just asking us to speak more generally about best practice in the U.S. I mean, I think I could speak from past experience in the private sector that there's such a depending on what regardless of what your product or service or technology is, there's such a saturation in the U.S. market that regardless of your point of differentiation, you still have to have that on the ground service and support. Because Australia's perceived, and it is in reality, to be a long way away if something goes wrong or if there's some type of a problem. So that's, from my private sector life and even from my experience here, that's what we've seen. If anyone wanted to add to that, feel free.
So we've seen that as well in clients, just U.S. customers. We have clients that really have no activity in the U.S., but they end up setting up a U.S. entity just because their customers feel more comfortable dealing with a U.S. entity, even though there might not be anybody here in the U.S. or anything like that. So from a practical matter, we've seen, it depends on the industry, it depends on the client, but we've seen where this has been done before.
Yeah, and I was going to say we've actually seen more of that even with pure software as a service companies, so even web-based software companies that have been servicing the U.S. market from Australia are now setting up, just even like a 1 or 2 person office to support their customers. So you would think if there's any industry or business that could be serviced remotely, that would be it. But obviously they found that that's necessary.
I'll add, I think that this also relates back to something that you said at the beginning, David, which is that the U.S. is a very, very large market, but it also means that there's a lot of competitors. And almost any product that you introduce into this market is going to have a competitor. So if someone's comparing being able to get someone here to provide after-sales service and somebody in Australia where they have to go to Australia, I think that's where one of the disadvantages may fall right there. Yeah.
I'd just also like to add that if anyone's thinking of bringing coffee to Houston, I'll be their first customer.
So one of the questions is using a consulting firm as an agent in the U.S. considered a partnership? Is that maybe you're using a service provider as a representative, or is that?
Well, I think that's what the question is going to is if I take someone who's in the business of consulting with a number of different parties and I use them as my local partner or agent whatever. Well, what does that do? Does that change anything? And the truth is that from a legal standpoint, you're really looking to the nature of what is the relationship that you have created. So you can create a relationship of various types legally, and that, typically the best thing is to really sit down and think before you create. Going back to something Raphael said, before you come to the United States, think about what you want. But if you want a consultant who does represent other products, you certainly can do that, and you can enter into an agreement with them for them to represent your product, or you can enter into a joint venture. Typically, in that situation, the biggest concern is that you may be giving some of your information to a competitor. So most companies prefer not to have someone who's in the business of representing large numbers of companies. The smaller you are, you may have to engage in that simply to access the market, but it does create these conflicts of interest and competition concerns.
And we did just get some feedback with regards to the last question around e-commerce and selling in the US. So we have one company here that's actually already selling in the US, and they're receiving credit card payments in US dollars via PayPal without having a US company. So there seems to be a way around that. A very specific one: shipping stock into Colorado. What taxes or duties would I pay on that? Maybe more broadly speaking, what are the types of taxes you would pay on that?
Yes, it depends. There's one thing that the customs side, and I have to disclose, we don't deal with the customs side of it, so the tariffs and things like that. I can tell you that having that stock in Colorado could create a situation we're talking about for the federal government doesn't see that you're doing business in the U.S. just because you have stock there, but Colorado may. And so you may be considered to be doing business in Colorado for that stock. Again, if that stock is just there for a few days and moving somewhere else, the answer could be different as well. So it really depends. Like I said, it depends on how long it's staying there, where it's staying. If you own your own warehouse, have your own employees on your own warehouse, or are you renting out a facility for somebody else that does that as their business? So, but in general, you'd probably be okay with not being taxable at the federal level, but you'd want to look at Colorado to see what the specific rules are there for what's deemed to be doing business in the state.
And similar question, somebody that's actually looking to put stock in a USA warehouse, they sell their product from their Australian website. Can they do that? Their experience is that looks like the warehouse is asked for an EIN, an employee identification number in the US. What is that? What does that mean, etc. Any talking points to that? I mean, I know there's kind of third-party fulfillment centers that you can put stock into, but I don't know if they expect you to have a US EIN. Yeah. I mean, there's other kind of third-party.
Yeah, and you can, and Olga and I have just recently talked to it. We talked with one client. Having a tax ID number doesn't mean that you're taxable. So if they're asking you for it, you can apply for one for different reasons. Doesn't mean that you're automatically going to be on the radar and they're going to come knocking at your door for getting a tax return. So you are, sometimes you need to get one to be able to claim treaty benefits. You have to have an EIN number, so you may need one anyways. So that doesn't dictate that. I'll still get involved with the tax advisor to make sure that that you're not tripping any wires in the process, but just getting the EIN itself, especially if there's a warehouse asking for it, they just want to know who they're doing business with. They want to know if they have to withhold taxes on any payments. And things like that, which is perfectly normal.
And non-resident obtain that number?
Yes. Yeah.
Excellent. And the final question: how do I find out about customs duties rates, the various duties rates for your product coming in?
Yeah, no, I was going to say that. I don't personally know an easy way to do that because it's a very complex area as to how the classification system. So you typically Again, I'll defer to lawyers in Washington, D.C. typically who specialize in this, and they carefully review the classification system for every product to make sure that there is the correct rate that's being applied to it.
Probably the Department of Commerce website
May have some beginning, yeah.
Yeah, that's a pretty active area of law in Houston.
Yeah, right. Yeah, and just to clarify, that's absolutely correct. That's not something usually your accountants will do. This is an area of the law that you want to make sure you get, and they're usually pretty specialized. The people that do that do nothing but that. So
Custom brokers, like a dedicated custom broker.
Well, that's another person. That's a non-lawyers who may very well have access to the same information.
Yeah, yeah.
I mean, we have the Port of Houston here, so that's it's probably one of the largest in the country.
I think the LA one is still the
Second largest by volume, but the largest international volume.
Right.
So you might be seeing a trend post that there's in the U.S. there's a specialist for every single topic that exists. So, so with that, I think we'll draw our webinar to a close. I thank everybody online for joining and sitting in. Thank you for sparking up and actually sending some questions after you've had your coffee. So thanks all. Just to reiterate, this is being recorded. We will save this webinar hopefully on our website, at least some location that we can share. Probably a disclaimer for everybody in this room. The information that they just provided answering those questions is general, and I'm sure it depends on your specific circumstances, which you can follow up with them directly. I'm not a lawyer, and I'm saying that. And I'd like to thank, again, all of our speakers sitting around this room, and Nikki and Sydney for taking the time here this afternoon in Houston and this evening in Houston to participate. So thanks, everybody, and we look forward to the next joining the next webinar. Thanks a lot.
Thank you.